All right, I'm going to take, normally I would start, actually. I don't think it's a bad idea that you've heard about adequate procedures and actually building ethical programs and hearing from these two speakers before me, because I can wake you up and look at the Act. Most of the time, you start with the Acts, and by the end of my session, you'll be sort of aware of what adequate procedures are and why you need to be wary of not getting it right. But actually, we've started there. So now we can look at this Act and we can have a little bit of a sort of banter and chat around where it's come from and so on. I think what's important is when I'm out and about, and believe you me, I've been speaking to lots and lots of clients since March 2009. When I'm out and about, I hear varying degrees of wariness from different clients. Some are obsessed. Now, if you work for an American organisation, then you start being obsessed and you work down from there. If you work for a French organisation, you start with the sort of, who cares, and you sort of work up. So it's sort of dependent on where you're headquartered. The UK is somewhere in the middle. You know, they're slightly bemused. Do we really need to concern ourselves? You know, it really takes a director going off to some session to come back and saying, oh God, you know, I might have some liability here, so sort it out. The Americans were the ones that actually started the ball rolling in the sense of with me, which I find quite interesting. The first compliance review and discussions I had was for a defence contractor in the Midwest in America about a year ago. I actually travelled out there ahead of the game. I was saying to them, this hasn't even passed through Parliament yet, guys. Do you really want me to travel out and do this? We want you there! We want you talking to the board! We're terrified! Everybody thinks they're going to jail. You've got to come. And so, you know, this sort of paranoia was there. But there is increasing regulation in this area. So when you listen to people, when they say to me, oh Neil, the UK, everybody's shutting up shop, we're all going to pack up, nobody's going to do business in the UK anymore, they're all off. It's absolutely rubbish. The reality of it is, if you are a corporate and you are caught out committing offences in a foreign jurisdiction, whether you have an office in the UK or not, you're going to be caught somewhere. And most global companies that do business in places like China or India or Brazil, the new emerging markets, they will have a listing in New York and they will probably have an office in London. They will get caught somewhere. Now, Rio Tinto is a good example, isn't it? Because the sort of perception amongst people, probably 5 years ago, is we need to worry about the Americans. If we're not listed in America, who cares? Because, quite frankly, the Americans are the only ones doing it. They're going, they're cleaning up, we don't need to worry. The reality, you know, nowadays is completely different because Rio Tinto shows directors going to prison in China. So more and more we're going to see corporates who get the issues wrong finding themselves in a multi-jurisdictional problem. Whether it's in the UK, whether it's in America, whether it's in China, whether it's Germany, and so on. And how the world has changed. I mean, I don't know who here, I can see some faces I recognise. But if we think about Germany, 15 years ago, it was legal to commit bribery overseas. And in fact, it was tax deductible, which is marvellous. But Germany today is a very different place, isn't it? 15 years on, and actually the Germans aren't far behind us in the sense of being committed to this area. So you don't want to be committing bribery and corruption in Germany, and you don't want to, if you're a business with German operations, to really be committing bribery elsewhere. So wise up a little. If you hear, you know, these little miserable moans, it's all unfair, think, yes, it is, but actually we have to step forward, and this is about a much wider global reach. Conflicting global mandates I've put there just to highlight the fact I know about InnoSpec and Dougal. I don't know if you're aware of them. Are people aware of them here? In essence, what's happening is when we talk about this multi-jurisdictional issue, you're getting the Americans leading, they're passing off information down to law enforcement agencies in other jurisdictions, and bang on, the corporate has to fight in all different places, different lawyers doing different things, and they try and reach a global settlement to end it all. And, of course, this is what we're trying to do because we've realised, hey, this is great. The Americans, they've got it all sorted out there. Everybody confesses, they all do their own report at their own expense, then they get a whacking great fine from the Americans. Couldn't be better. We want a piece of that. And so we saw in cases like InnoSpec that attempt. But of course, the British courts aren't too happy about it. It goes against our principles. You can't plea arrange. It's up to the judge to decide on level and so on. So they've been hit by it. We look at the case of Dougal. Dougal was a cooperating defendant. He was a vice president of DuPont International, a subsidiary of Johnson & Johnson. Yeah, he goes forward. Great. I am guilty, he says to them. Treat me kindly. And they say, we are. We really like you. You're a great guy. You've come forward. Brilliant. And they go off to Southwark Crown Court and they come across, and I'm a high rights advocate and I've come across him and he's a difficult judge. They come across His Honour Judge Rivlin. Now, does anybody know His Honour Judge Rivlin here? Well, he's an interesting judge. So they go and they say, Judge, be kind. Because this guy came forward. We think he should get a suspended sentence. Rivlin says, nonsense. I'm not being told what sentence. This is a heinous, terrible crime. He's going to prison for 12 months. So they march off to the Court of Appeal in hope the Court of Appeal are going to support them. And they say, Court of Appeal, help us. And the Court of Appeal say, we're not going to help you on that. We're going to fudge it, actually. So the Court of Appeal say, well, you shouldn't be telling a judge what to do. You can't reach agreement outside the court. However, we think His Honour Judge Rivlin has been manifestly excessive, and therefore we will, surprise, surprise, implement a reduced penalty of a suspended sentence. So they got there in the end, but only after Mr. Dougal had gone to prison for a week or two. So it is a watch this space. We'll probably see judicial guidance coming out around it, but it's certainly an evolving area. So if you're thinking bribery and corruption, don't forget to think increasing regulation elsewhere in the world, global settlements, that is the future. Agencies now geared to enforcement. Look at the FSA with Aon. First out of the hat, aren't they? We've all forgotten that now, haven't we? £5.25 million fine in January 2009, just ahead of the bribery bill coming out. The FSA saying, my God, what a brilliant way. We did a thematic review and nobody paid a blind bit of notice. But we prosecute, or we don't prosecute, but we take regulatory action against Aon, everybody sits up. What sort of message is that going to send to the SFO? If Aon happened now, they were done for breaching Principle 3. It's all about their overseas intermediaries. If Aon was to happen now, you can bet on it, they'd also be prosecuted for failing to prevent as well, unless they could show the defence, as we've heard, of adequate procedures. And don't forget, the SFO has new tricks up its sleeve. This is a very different organisation to the one that used to exist, really. I was a fraud lawyer for 13 years up to 2008. I'm now at about 15 years qualified. And the SFO never spoke to me. No, I went with clients, and they opened the door then, and then they shoved us out at the end of the day. But during, I think it would probably have been late 2008, early 2009, my secretary comes into my office and she says, Neil, the director of the SFO would like to see you. So I said, well, I don't particularly want to see him, why does he want to see me? You know, I haven't done anything. I was just thinking of all my cases, my God, this could be serious. Do I need to tell head of compliance or what? So I said, phone back and just try and find out what's going on. So she comes back and she said, spoken to his PA, he just wants to have breakfast with you. Just wants to talk to you. So I said, fair enough. Okay, I'll have breakfast with him. And he's quite, I don't know if anybody's met him. Has anybody met him here? We'll see him speak. The guy's an ex-tax prosecutor. You know, he's not a great bundle of laughs. And I've got to say, I fell into his first trap. He took me to a very nice restaurant. And of course, I ordered egg, bacon, sausage, beans, full works. The waitress looks at him and he says, I'll have a bowl of fruit. And he looked at me with complete disgust. So I had to nosh away while he said to me, look, things are changing, Neil. He said, I want you to send the message to your clients to come and speak to me if they have a corruption or bribery issue in particular, because I'd like to treat them really kindly. And also he said, I'm going to create these new self-reporting guidelines and it's going to be really wonderful. So I said, well, for whom, Richard? I mean, when am I going to decide to do this? What is the stick that you're going to beat us with? Prosecution. It's coming, he said. Prosecution, that's going to be my stick. And he got quite animated. So he was already thinking about civil settlements, the idea of civil recovery orders. We know Balfour Beatty was first. This idea of avoiding prosecution if you fess up early enough. And where does he come from? The tax, HMRC. He's bought up on tax settlements, civil settlements. He loves them because he knows he gets that lovely headline. And what is this system going to do? Well, he knew, having gone to Washington, that the Americans had no better resource than the SFO. But they had a record that was 100 times better. So the idea of getting you guys to do your own investigation using people like me and Ben and Martin, you know, making us do the work for you, charging you, you go along, you tell them what you've done, they say great, you've now got the proceeds of crime, 3 million quid, we'll go to the High Court, you fess up there, you avoid a criminal prosecution, I get a great headline in the newspapers. The SFO cleans up corporate Britain. Or the SFO targets big corporate PLC. It's a wonderful win-win for him, isn't it? So, whilst we're going to look at the Act, and I can go across quite quickly on adequate procedures, bear these messages in mind. This is a new system, and I think it will only become one that's more ingrained in our culture, not less ingrained. And if you hear those sceptics who say, oh, it's going to happen, yeah, there isn't going to be that many prosecutions. I think we're going to see quite a few corporates fessing up, actually, and trying to get civil recovery orders to shut down investigations quickly and save costs. But I think you're going to see very few of the ones that they instigate. But be warned, it could be you. It could be the Americans passing them the material. It could be other jurisdictions. There's a much cosier international network out of there. Okay, timetable you've seen. What I would say is this consultation period is around adequate procedures. I had a general counsel, hopefully ring me did, and he said, does that mean they're thinking about dropping the Act? So I said, no, it's definitely coming in. Sorry, oh, drat, he said. And he, you know, what was interesting, and I know this for a fact because I've done work with the Shadow Justice team now, coalition government, is basically what happened. And I'll say it on Chatham House rules, please, for a second. But basically what happened was the coalition government came in and said to the Ministry of Justice, this is great, this new piece of legislation is lovely, we know we supported it, what are adequate procedures? Don't know. Do you know? Oh, you don't know. Do you know? No idea. So David Cameron in his Open Britain created a consultation period so that we could input and they could actually be given a bit longer to come up with them. So it's allowed them to do it in January, and that partly explains why the Act is taking a year to come into force, which is unusual, isn't it? But the reality is that it's here to stay. There are other questions which we'll look at. One is around the corporate offences, what constitutes doing business in the UK, or part of a business. Anybody know? No, because nobody knows. The Americans, I was over at an event with the General Counsel of the SFO, I had a very, very excitable DOJ prosecutor who's telling me, apparently, that the UK, that it could be anything. He said, oh, using the banking system would be enough, Neil. Absolutely. Using the banking system, having meetings, it's going to be great, they can grab them. So I said, I'm not sure that's what it means, because I think Vivian thinks it means you've got to have at least have a bit of an office, and then something to serve on. And he said, oh, no, he said, no, I'm not sure. But basically it's left open, so who knows? You know, the SFO may take an approach in 2011 that they then disregard in 2012 or 2013. So foreign incorporated companies, people coming into the UK to do any form of business, are at risk. You haven't gone through the different offences, but I am very briefly going to do it, so please, please, please excuse me for this, but I'm a lawyer, so let's tell you. I've given these headings myself, general, specific and corporate, okay? We've been talking about this a lot, haven't we, the corporate offence. But be warned, there is a general and specific offence here for UK incorporated entities and UK nationals and UK residents that doesn't affect this offence at all and has some very nasty little provisions to it. Well, what is active and passive bribery? Active is the offering, promising or giving of an advantage, financial advantage or other type of advantage with intent to induce somebody to do something illicit. Bear that in mind, that's what active bribery is. You need an intent to make them do something they wouldn't otherwise do. And then apply that just to our golf day for a second. Okay, I'm going to play golf, I'm terrified, am I going to be bribed over the golf course? You don't hear many people saying that, do you? But you hear lots of companies saying now, oh God, can we do our golf day? What can happen? I mean, what are you doing behind the 9th bunker? Are you saying, listen, you know, you bought that contract and we'll invite you to another golf day next year? I mean, what are you saying that is going to induce them to do something illicit? Nothing really. The golf day is safe, isn't it? Different if you're going to fly them to Florida to play golf and invite their family along, take them to Disney World, maybe give them a present of a Rolex at the end of the day. That's completely different, because your competitor would think if they saw that, oh, I'm not really happy with that. That sounds really dodgy. Use the sniff test around your policies. Passive is the agreeing to receive something or receiving something to do something you shouldn't do. Okay? So it's the other end of it. Now, these provisions, and we'll look at in a minute, have something nasty called director's liability. So, and consent and connivance provisions. So bear that in mind. So does this offence. All right, bribery of a foreign public official. Now, this one's quite interesting because let me read the definition, because remember I told you about intent here, intent to get them to do something illicit. Well, actually, this offence says something completely different. It says a person who bribes a foreign public official if they intend to influence them. They must also intend to obtain or retain a business or other advantage. There's no intent to get them to act illicitly. All you need to be doing is intending, by your actions, to obtain or retain a business or other advantage. Ooh, blimey, it gets a bit dangerous, doesn't it, when you look at consent and connivance provisions? What the hell does that mean? Not quite sure, really. It just means you have to be very, 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 very careful around foreign public officials and what you're doing with them. So, general and specific, UK incorporated entities only. Does affect the public sector though as well, and of course you've got consent and connivance provisions. Corporate offence, any company incorporated anywhere in the world, has to be a private company, that does business or part of a business in the UK. Alright? No directors go to prison here on this offence, just a fine, could be unlimited, could be very expensive, debarment from bidding for public contracts as well. So it's pretty serious stuff. And don't forget the FCPS wider than that because it covers all transactions, not just those with foreign public officials. I'll look at facilitation payments in a minute, but they're permitted under the FCPA and they're not permitted under the Bribery Act. So we've got another divergence. Just think about this for a minute. The Americans, who we know love investigating, they look at your company and they get the details. And finally they sit there and say, oh, bugger. We really wanted them, but they haven't bribed a foreign public official. It's another commercial entity. What are we going to do? I know. Let's phone our friends in London. We can help them. They can sort it out. There's a real risk around America. I'm convinced about it. Okay, here's the personal liability that we talked about. This is the bit lots of people miss because it comes about, we first saw it in the Fraud Act 2006. It then emerged in the corporate manslaughter stuff. In the old days, under the current legislation, to corporately prosecute for the general offences, you've got to show a guilty mind of the company, haven't you? Very difficult to do. Very difficult to do. How do you link it up? This is slightly different. If you've got a senior manager or officer who's either complicit or turns a blind eye, might be enough, you could be caught as a corporate. So just think about this. You've set up your wonderful policies that we've heard about. It's going great. Your HR manager receives the whistleblowing report. He says there's a big problem going on in China. You think, got to sort that out. Really got to sort that out. But we're just merging at the moment. Sorting this out. I'm going to do it. 4 months later, the SFO raid. Compulsion requests. And the activity's been ongoing. That HR director is implemented. It is now implicated in the activity and could be prosecuted as so could the corporate. So actually having policies around investigations that work is also very, very important. Because look at that, up to 10 years imprisonment, direct to disqualification, it's a career-ending situation. Consequences of not taking it, well, you've heard a lot about that today, so I'm not going to go into it. The cost could be huge. So if you're speaking to your board, and they're saying, just look at Siemens. What are they up to? 900 million in legal and accountancy costs. Oh boy, I'd love to have been in that case. I wouldn't be here, would I be sipping champagne somewhere? Toasting Siemens. But, you know, that's the reality. And here we get headlines coming, haven't we? This is the SFO talking about when they would prosecute. You know, is it significantly serious? And look at the areas they're looking at, all those nasty ones that companies like to avoid thinking about. Those third parties in particular. So, you know, a really, really big area to look at. And here, look at this, some UK retailers telling UK-based clothing importers to actually take control of their overseas manufacturers and even acquire them because of concern that they could be committing corruption down the chain. Really, really, really causing stress for corporates, isn't it? Okay, well, you've heard about the adequate procedures defence. I'm just going to say one or two things about it. Of course, it's not prescriptive, which makes it difficult, but let's just look at these 6 principles and I'll just tell you a story about each. Regular and comprehensive risk assessments. Okay, we looked at Transparency International, and I've got it somewhere here, and I thought that I would raise a few things. Because when you risk assess, I've heard from companies, oh, all happens in the Middle East, Neil. Oh, yeah, all happens in the Middle East. So either we just don't do business in the Middle East or we pay these payments. Incorrect answer. Because when you look at this, this doesn't show that the whole of the Middle East is corrupt and the whole of Europe isn't, or North America isn't corrupt and Asia all is. These are the interesting facts from this year's, which I thought are really good. Italy is at 67, but at 66 is Rwanda. So Italy is actually worse than Rwanda, according to this. My goodness me. Who's above that? Oh, Samoa and Ghana are above that. My goodness me. Italy, all the way down there. Greece. Well, Greece is even further down. My goodness me. Greece is at 78, just behind Colombia. That well-known country that's likely to not have corruption going on. It's significant, isn't it? Because Cyprus, I can't work this out, Cyprus comes in the top 30. So Greek Cyprus is somehow safer than Greece. Doesn't make sense to me, but anyway, according to Transparency International, that's the case. Now, let's look at two countries that sit side by side almost. Uruguay in South America, just behind us. Paraguay, 146th, just ahead of Libya, Iran, Cameroon and Pakistan. So just think on, when you're risk assessing, do it properly. Because it is not enough to say all of Asia is corrupt. We know Singapore, for example, is at #1, and the rest, you know, all of South America is terrible. Not the case. Look at it and learn from it. And I know that Ben covered a lot on this. Top-level commitments. How many times have I sat with clients, talking to them, and when I say, who's going to be your anti-corruption officer? And they all look around the table and everybody goes quiet so that until a victim is picked. Or they try and pick the MLRO. You know, big organisation, MLRO is talking about money coming through, customer money and stuff. It's not about money being paid out. So think on about how you do it. Due diligence. Those clients who say to me, yeah, we can't understand this whistleblower at all. I mean, we pay 9% commission to this one agent. He's really brilliant. I mean, he gets brought us so much work in that part of the world. Has he? How much work has he brought? Oh, loads. Really? Well, he's very good then. Where did you find him? Well, we acquired this entity and he came with it. It was great. What do you know about him? Not a lot. What's the standard commission rate in that country? Oh, no idea. Sure, it's whatever we pay him. Paid him a lot of money. And they suddenly twig when they start saying he's so brilliant, he gets us lots and lots of work, that maybe there's a reality behind it. Know who's doing business, for God's sake. Know who's doing business on your behalf. We talk about due diligence, it should be obvious, shouldn't it? But how blind did people come? Especially when they've acquired entities in places. How blind did they become to it? Oh, that's what happens there, but they don't ever check it out. Don't put stuff in and do proper due diligence checks. Clear, practical, accessible policies. Make them readable. All right? People say to me, I don't need to train, we've got policies, they've all read them. If you ask the average person, you know, we'll all do this at work. You get the thing, don't you, on the email, I've read that, click, yeah, no problem. You then ask them, what does it say? I haven't got a clue. I haven't got a clue. Or I read policies that are so legalistic that nobody could possibly understand. Well, I don't, I'm the lawyer. So make them readable, make sure that people understand them. Effective implementation and monitoring and review are probably really, really, really important. About as important as they get around adequate procedures. How do you know they're properly implemented going forward? On monitoring and review, I did a session with a company who took it seriously. We did a risk assessment workshop. They brought people from around the world. It was all going swimmingly well. And I said, how are you going to do your internal monitoring? And the guy said, no problem, we've got internal audit. They're brilliant. And the guy from internal audit didn't look very happy. So I said, what have you got to say? And he goes, well, I'm not trained on bribery. We don't do that as part of our internal audit. So think through how you do it. Some are using external providers, like Grant Thornton and others. Others are gearing up and resourcing properly to do it. Oh yeah, I forgot my effective implementation story. Whistleblowing hotlines. How easy are they to implement? Well, I've been working with a GC who told me a very, very interesting story. I know I can recount it because I've asked his permission before. He's tried to bring in a whistleblowing hotline in France. Anybody tried to bring in a whistleblowing hotline in France? Are you still alive? So that's a good sign. Right, the French say, oh, it's a terrible you know, the Gestapo in the Second World War. Anyway, they're stuck on that. They think it's the Gestapo or something. So they don't like it, so the unions get involved. So anyway, this robust GC, and he said, we're having it. I went global, it's part of our procedures. No, we're having it. So they said, you need to speak to the union guys, not happy. So they said, fine, I'll come to Paris, we'll do it. He gets off the train at Gare du Nord, gets a phone call saying, there's a riot going on outside our offices at the moment. And he's saying, well, hold on, why? Because of you. They're rioting because of you. They're waiting. So you must go back to London. So he said, no, I'm going to go. He arrived, he said there were bricks being thrown, he had to have police protection to get in, they were doing all sorts of stuff, all because of a whistleblowing hotline. Now try telling that to the SFO. Oh, the SFO go, oh, you must have adequate procedures, steady easy, just made, you know. Every jurisdiction has its problems. When you look at your jurisdictions, if you have them, then you have to look at your high-risk ones and work out how you can achieve an end result. Now, he did get it in the end in France, and I'm not saying that every company would manage it, but he did manage it in the end. And sometimes it's through hard work and perseverance that you can do it. Okay, difficult issues. Gifts and hospitality. I love this one because companies are obsessed with it. They're completely obsessed with it. We can't give our pen set anymore at Christmas. Why not? We could be wrong. Good. So someone's going to award you a multi-million-pound contract because you've sent them an Aviva pen for Christmas. I mean, you know, okay, is it okay? I mean, could you give us an advice that says, like, we put it on file and if the SFO try to prosecute us, why are the SFO going to prosecute you for sending a pen set? Now, I did have one client who said, which I think is just a little bit over the top, they sent Mont Blanc pens at Christmas. Now, I'm thinking, a great client, I want one of those. And I said, well, I think that's not a sensible thing to do because it could be misconstrued by your competitors. And it could give you just an edge because people like Mont Blancs, like Rolex watches and love them. So I said, just get a nice pen and engrave it with your logo. Give it a nice box that says Grant Thornton or Evershed. It's fine. But be careful in what you do. The other one I think is quite amusing. We did an event at Eversheds, and we were talking, and it was an open discussion against Chatham House, and people could say what they like. And this guy said he was from the investment banking community. Is it the end of taking clients to lap dancing clubs? And we had a little discussion with a couple of robust women GCs who didn't look very impressed with it, I've got to say. I said, oh, honestly. And we sort of had a chat, and I said, well, how's it going to look at the SFO if we suddenly, you know, that night at the lap dancing club didn't influence the contract was awarded a couple of weeks later. The very fact that we paid a couple of £100 just to help the CEO with a private dance, I'm sure didn't influence anything. It doesn't smell right, does it? Just to me, it doesn't. Now, okay, we had that discussion, and he told me he's going to continue, and that's what happens. And my brother-in-law's an investment banker, and I've had the same discussion with him. He's got some sort of corporate hospitality card at Spearmint Rhine and loves it. And if it was taken away from him, you might as well just give up if they're going to chase it down. But it is a problem, isn't it, which you need to think about. These are thorny issues around it. You know, we don't have defensive promotion expenditure. Hopefully you've read it. Let's just have a look at this. You know, gift of a holiday to procurement manager. These are pretty obvious. They're going to have a problem, aren't they? BAE, the £750,000 Maybach car that's given to the Saudi prince. Right, it's all in public, so I can tell you about it. He rejects it. He's not happy because it hasn't got gold umbrella holders in the back, which he wants put in. You know, this isn't a golf day, is it? I mean, this is extreme stuff, isn't it? Lavish dinners for clients at top restaurants. Well, I think that's okay, really. I mean, it depends who they are. If you're celebrating something, you've done a great win in a legal case, I wouldn't mind being taken by a client somewhere, or taking Ben out. I mean, I could take Ben, I'm sure, somewhere good, and he's not going to...
I won't act properly for you, Neil.
Thank you very much. I'm not going to do the same. But it needs to be recorded and dealt with. You need to think it through very carefully. I am very suspicious about the, you know, the idea of going abroad for things. Vivian Robinson seems to think it's fine. I've had this discussion with him. He's the General Counsel of the SFO. It's fine for us to take clients to the Millennium Stadium to watch Wales versus England. But going to Paris to watch France versus England and stay there for the night, could change it. And I said, why? He said, you've got an office in Cardiff. So I said, we've got an office in Paris. So he said, well, okay, you've got an office in Paris, but it's still a different jurisdiction. They're not coming from the French office. So I didn't quite get it. So I think their thinking around it is, they again think it's sniffy. So all those companies that took people to South Africa to watch the World Cup had problems. Your third-party issues are important. I know we've covered off those. bear in mind these people can capture you. And here we have, you know, the sort of stuff that you generally see when I'm looking at a case and investigating. No doubt Ben's seen this as well. You know, we go, the accountants are looking, we're looking, we get the documentation, and what do we have? People don't know who is doing business on their behalf. You know, you can be caught under that failing to prevent offence for the acts of your third parties. Your granny can catch you. You don't actually need to be in a contractual relationship. If Ben's granny goes out and says, and Ben doesn't know this, his granny goes out and says, I just want Ben to be really well at Grant Thornton, so I'm going to give you my life savings to send send all your client work to Grant Thornton, and they do it, then Grant Thornton are effectively caught, even though they have no knowledge or understanding that Ben's granny's doing that. Pretty serious stuff, isn't it? And again, we've covered off this, but look at your policies and procedures around it. Group companies, this thing I get asked all the time, who catches who? So let's look at this. US holding company with a Korean subsidiary engaging in corruption in Korea has a UK sister company. Do we think the UK company will be liable for its sister company's corrupt behaviour? He wants to be brave.
Yes.
Will it? Depends, actually. The Act is quite clear in that what it's saying is, jurisdictionally, a foreign incorporated company can be caught, yes, and it can be caught by the acts of others, but what you've got to bear in mind here is the UK sister company is in the group structure, but it won't be caught by the acts of its sister company unless the sister company is actually committing bribery and corruption on its behalf. Now, it may be that, say, for example, it is going to one supplier, bribing them to get cheap supplies that go to the UK sister company, in which case the UK sister company gets caught. But if you just had a completely distinct division that does its own thing out there, then the UK company should be all right. So it's a sort of, you've got to be very careful on jurisdiction. I was giving advice to a big Australasian outfit that has group companies in the UK. And actually, I went to see the SFO to talk through the jurisdictional issues with them, and their shutters are up. By the way, they will speak on a no-names basis and give some advice on it. They have 3 employees, the Australian entity, in the UK, offering advice to the UK group company on group issues, which the UK company is billed for and pays. Are they caught? What do you reckon? Correct, because they're providing services in the UK. So even though the whole of their acts are outside, the fact they have these 3 employees in there means they're caught. However, what did the SFO say? Robert May, head of corruption, used to be my trainee. He says to me, but I would exercise my prosecutorial discretion because the likelihood is I'm already interested in the Australasian company committing bribery there. I would pass all the information that I had back to the appropriate authorities there. Well, will he be right on that? We'll have to wait and see. Potentially they're caught. He would say not. Facilitation payments, very quickly, I know we're about 2 or 3 minutes. Facilitation payments are routine government payments to speed something up. Okay, don't confuse them with bribes. Okay, lots of companies say to me it's a facilitation payment, and I look, it isn't. So, for example, I'm entitled to drive down a road, I'm stopped by the local police, they say, I pay my road tax, they say, in order for you to have your lorries going, I need, as police chief of this area, $200, please. Okay? That would be a facilitation payment because they're actually entitled to be doing it. It doesn't speed up the process, and so it's just on the edge of the definition, but I take that as a facilitation payment. It's nothing to do with the main contract. However, I'm stopped, I'm overloaded in my lorry, I pay the $200 so they turn a blind eye. I'm actually gaining a business advantage because I'm able to send my lorries down overloaded by paying this amount. Bribe. Bribe, 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 bribe. Don't get confused. Now, interesting, I had some great discussions with the SFO. I went to see Bob Evans, who was head of outreach at one point, and I actually played devil's advocate a bit, and I said, come on, give corporates a break from facilitation payments. Now, he looked really angry at this point. I was with a colleague, actually, he looked really angry. He'd just been in America for 3 weeks. I think they brainwashed him. They put him in a room. Bribery's bad, and he'd been sent back. He banged the table, and he said, when is corporate Britain going to wake up to the fact these payments, he said, create the environment for larger payments to be made. Those corporates paying these things, they're more in tune to pay stuff to get their planning permission through. Before you know it, they're paying £50,000 to some government official to win a contract. It's disgusting. And he looked really sad and appalled. And I thought, ooh, okay, I know where you're coming from. And that's an absolutely true story. And I was with a colleague, he got quite angry with me for suggesting that it's appropriate. Are they going to prosecute on a facilitation payment? Well, you know, they're not going to be prosecuting anything unless it's complex and over £1 million. So the likelihood is no. But are they going to investigate a company? Potentially yes. What about the CPS here? The SFO tell me, oh, we're the lead agency, CPS aren't interested. But actually, if you speak to the CPS, they say, we've got the ability to prosecute. Why can't they prosecute this? It's failing to prevent. Easy peasy. So again, we'll have to watch this space, and it's something to be worried about. Incentivisation payments to staff. How many of your companies do this? Or to agents? None of them? Okay, well, you've got to be a little bit careful, because just think about it. You win a holiday. So you are a supplier to customers, you've got 3 different customers, and you favour one because if you reach the sales target, you get a lovely holiday in Barbados with your family. Potentially problematic. The SFO don't like it at all. They think that is bribery, by the way. And so actually working out the way in which incentivisation schemes can remain on the right side of the law is important. And just to finish off, a minute or two behind, or a minute behind, I mentioned at the beginning, so I'll finish where I started from, the SFO developing new tools. Self-reporting is one of them. I went to a talk where Robert Wardle, the ex-director, said it's a brave man who doesn't self-report. I don't agree with him. At the moment, it might be a brave man that does in certain circumstances. There are going to be occasions when, if you're investigating properly, you will make an early decision that it's absolutely the right thing to do. Whistleblower scenario, SAR reports submitted by your auditors. There could be numerous ways in which the SFO would find out anyway, in which case, if you think you're going to be at risk, you get in there first and do it. There will be other ring-fenced types of activity where you might make a different decision, but they have to be really based upon what you see, because actually self-reporting isn't a get-out-of-jail-free card. Maybe Johnson self-reported and still prosecuted. And it is a very complex issue, and one that you will need advice on. But, just think about this, and I'll finish with this thought. You get into bother because you have an agent overseas that does something. You need to quite quickly decide what you're going to argue. Are you going to argue full defence, got adequate procedures, or are you going to say, actually, our adequate procedures weren't quite up to scratch, although we've got them in, we're very ethical, and we've learned by it, so we're going to go down the civil recovery route. And you're going to have to think about, to avoid a prosecution. So you're going to have to think about that quite quickly. That means, unfortunately, 2011 will probably be a better year, 2012, for being a fraud lawyer. It's amazing how my role has developed in the period that I have. It doesn't seem long ago that the proceeds of crime came out. But there we are where we are. So think on. You've heard why you need adequate procedures. Hopefully I've explained with a few more stories and why it's important to get it right. I don't think all corporates will, and I'm told by the SFO that they will not always prosecute. And they will not always seek civil recovery orders. So that means there are those corporates who are ethically minded, who can show it, who can have proper representations made on their behalf, who will hopefully escape anything nasty happening to them. And that should hopefully conclude. Thanks very much.